is also prescribed, that is Form I. Probably at page 114. Form I, second page, it's a Romans small 6. He has to specify the mineral or minerals which the applicant intends to mine. My Lord Justice Pardiwala has got this one.
Which page?
Well, the Form I, Form I,
Have I also seen clause 2 at the part 6?
Clause 3, Roman 6.
Yes. What page was that?
My book is 114,
Roman 6.
For my
114, 116 maybe.
114. Minerals or minerals for which the applicant
Yes.
If you see
And the
clause
period.
part 6, provisions relating to rents and royalties, for clause 1 says that rent and royalties to be free from deduction, but clause 2 is very important. For the purpose of computing the said royalties, the lessee shall keep a correct account. Now what follows is important, of the minerals produced and dispatched. The accounts as well as the weight of the minerals in stock or in the process of exports may be checked by an officer. So therefore, the liability to pay royalties
Rule. Yes.
So that time he has to pay.
is payable. The liability to pay a royalty arises when the decoupling has taken place.
Yes.
Namely, that the mineral has been extracted and at the point of removal.
Yes. So that's the point of decoupling, not at the time of grant of lease. At the time the land is as such, we transfer the land also to occupy. Unless we transfer the land, the lessee cannot do the mining. The mining rights will be useless. So that mineral rights and the lease of land go together. And the lessee has to specify in the application what minerals he wants to mine, the period, the extent, the details of the area. So he's making a conscious choice. And even with respect to period, the law says minimum 20, maximum 30. So there is a range of 20 to 30 between which the applicant and the state government will have exercised their discretion, and a bargain will be there to fix the period, exact period. It could be 25 in between. So it's not that contract is absent, in the case of state granting.
Now what next? Sorry.
Mr. Dwivedi, what Mr. Pardiwala, Justice Pardiwala had just now mentioned about
Yes.
Giving up, page 137.
Yes, Manoj.
Now don't look at it so seriously, but when a miner goes down
Yes.
in order to extract the minerals for which he has already paid something, and he finds a placard there, Queen Isabella is already here
Yes.
or was already here. And he says, I give up the rights for.
Yes. Yes, that's right. So that was the first point which I was making, that under the Act, rules, forms, the alienation or segregation, separation or decoupling of minerals from land happens upon exercise of the mineral rights post grant of lease.
Again, let's take it again.
The alienation, segregation or separation, which is the more appropriate term, or the decoupling of mineral from land happens under the 1957 Act Rules and Lease, Form K. Only upon the exercise of mineral rights by the lessee and not at any prior point of time thus the law is consistent with the natural phenomena of the minerals taking birth and acquiring shape in the womb of the earth.
Subsequent to
And second, my lord,
lease.
the lease itself shows that one, this is a contract, albeit statutory. But the essential elements of contract, namely the making of application, with an undertaking to comply with law, including payment of royalty, and the acceptance of the application by a grant order under Section 4. Along with execution of lease, which states that it is an agreement, would show that the lessor and lessee have to agree to the terms.
So when
More than this, Manoj, if the central government itself does the mining under Section 17(3), it will have to pay royalty, dead rent, surface rent, at the same rate at which is payable under Section 9 of the Act, as if, the words are, if such, as if such mining has been undertaken by private person. This is a fiction created by central government, rather by the Parliament itself. That even central government, if it does, is treated to be a private person. But we are told that it's a relic of past.
So when Form K is executed, is it a grant of a mineral right?
Along with the land, the mineral rights are also granted. But for the lease, Section 4 says there will be no mining except under the lease. So the mineral rights are transferred, they belong to the state, they are transferred. I can do mining myself, the state can do it itself. Reserve it. Earlier, till introduction of 17A, that is 10th of February 1987,
A mineral right?
the state government needed no approval of the central government. 17A. But after this, under 17A, the state government, if it wants to reserve, under 17A2. So now we need approval of central government, but up to 87, no approval was required. We could say that we will do the mining under our own corporation ourselves. Now, Section 17(3), when it says that central government will pay royalty as a private person, it is acknowledging that the land and the mineral belongs to the state. And that is why it agrees to pay royalty. It is not agreeing to pay tax to the state. It takes the lease in the same manner, therefore you pay the royalty in the same manner. There are only two ways in which the state government can be deprived. The first is either the Constitution itself provides that the land and mineral will vest in the Union. That is Article 279. Just say not 279.
Yes.
Shelf. That is regarding the economic shelf, the economic zone, and
Yes.
Right.
297, I'm sorry.
297.
297.
The numbers were reversed, 297, 297. That's one way. The second way is acquire the land by means of an acquisition act by law referring with respect to entry 42 list 3. And in fact, if the Lordship looks at Article 31AE, even private rights, existing leases, the rights can be extinguished by law, which then will be protected if it is under 31A, protected from challenge based on Article 14, etc. Notwithstanding anything contained in Article 13, no law providing for E. In fact, A and E can be read together. The acquisition by the state of any estate or of any rights therein, or extinguishment or modification of any such rights. And then E, extinguishment or modification of any rights accruing by virtue of any agreement, lease or license for the purpose of searching for or winning any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease or license.
Farm, a huge farm of 100 acres.
Yeah.
100 acres. And I come to know that some part of my farm,
If you say
there are
that,
minerals. I cannot start extracting those minerals on my own because minerals not of my ownership.
maybe it is a result.
Still, there has to be a lease deed,
Lease deed.
right?
Mm.
So lease deed will be only with respect to extraction or removal of the minerals.
Correct.
Land belongs to me.
And if your lordships are having on the yourself to you want to do the mining yourself, then of course it will be relating to permission to excavate.
Royalty has to be paid because I'm removing it,
Yes.
removing the minerals.
So that's the notion, my lord, that minerals always belong to the sovereign, the state.
Can you just read section 17.3 again, Mr.
Section
17.3?
73, yes.
On the article 285. Relative.
Where in exercise of the powers conferred by subsection 1A or section 2, the central government or the state government, as the case may be, undertakes prospecting or mining operations in any area in which the minerals vest in private person. It shall be liable to pay prospecting fee, royalty, surface rent or dead rent, as the case may be, from time to time at the same rate at which it would have been payable under this act, if such prospecting or mining operations had been undertaken by a private person.
17.
This is 17A3. Your Lordship wants to me to read 17.3.
17.
70, where in exercise of powers conferred by subsection 2, the central government undertakes reconnaissance, prospecting or mining operations. In any area, the central government shall be liable to pay reconnaissance, permit fee or prospecting fee, royalty, surface rent or dead rent, as the case may be, at the same rate at which it would have been payable under this act, if such reconnaissance, prospecting or mining operations had been undertaken by a private person under a mineral concession.
Now, until the actual extraction takes place, or removal as this statute uses the word, is it possible, of course, that the right to the surface of the land vests in one person and the rights to the mineral vest in another person? That's also possible?
Depends on the terms of the lease, what is being.
No, even before, forget the fact that there is a lease. Can there be a situation where the surface rights vest in A and the right to minerals vest in somebody else? For instance, service rights vest in the
It will go with
private
the land.
person
No,
and the right to minerals vest in the state.
it will go with the land. They are the right of the landowner. So unless by law or by contract, a notional separation is brought about in the two, it won't happen.
Yes.
Oh, but in private.
Now, before I leave this, Your Lordship may just have one more clause of Form K, which is the last clause, 9. of Part 9.
Said 137.
Page 141 was.
137.
Begins at 137.
136.
You are saying part 9, right?
Part 9, clause 9, the last clause.
That's clause 9.
For the purpose of stamp duty, the anticipated royalty from the demised land is so and so per year.
Sorry for the interjection, my Lord the Chief Justice's question. Kindly look at section 24A,
24.
24A, subsection 2. You might get an answer, my Lord. This is the question which fell for my Lord, this is Padiwala. Whether a surface right of somebody, mineral right is somebody else. 24 capital A 2, subsection 2.
Which section?
24A.
72. Carrying it here.
24A has nothing to do with that.
In the rules, is 72 of the 1860 rules.
Section 24A doesn't answer that.
Was because if the law contemplates a situation where the title to the surface vests in A and the right to minerals vests in B, then does the law then not provide for an artificial decoupling
Yes. No, law can,
even prior to removal?
it's not my submission that by a constitutional amendment or by a parliamentary law, or since the power of regulation is with them under entry 54, one has to see, to what extent they want to provide. So there will be some stray cases, if at all, where because of joint family or something, they divide amongst themselves that some part goes there, some part goes to somebody else, which is a very unlikely situation. And perhaps may not be very helpful in answering the controversy which is your lordships are considering. And so far as 24A is concerned, it's only a case where a private person's land, if somebody is.
Also recognizes that's what.
So yes. The 1960 rules.
Same as 24A, that
Yeah, but-
holder of lease will pay to the owner of surface.
Just a question developed. It's filled for
It doesn't, these will apply only where a private person is having a land which is having mineral, and then some third person wants to do the mining on that, then lease is granted by state government under section 4, but surface, therefore surface rent is to be paid to private person. That's all it's saying.
Just come forth, since we are in a key area, do you want to add just one sentence without affecting Mr. Dwivedi's, because we are almost come.
Was considered by the Supreme Court in the direct issue I was mentioning at that time, considering the Hasbury's law of England, specifically saying that both can be held separately. But normally the presumption is that everything up to the center of the earth, including mines and minerals, vests in the person who is the owner of the surface. But there should be a legislation.
Take away the mineral.
Take away the.
That's what Mr. Dwivedi also.
This is the fundamental that the judgment is,
Just give us a citation. We did.
that is Tarakeshwar.
I will cite that judgment.
You're citing, then it's okay. Mr. Dwivedi is going to cite it. Mr. Dwivedi, don't forget just when you are.
Yes, yes. The lordships have seen that stamp duty
Yes, we saw that.
is a different entry, but royalty is the measure.
Major. That is the major.
I will elaborate on this aspect when I again come back to the constitution. Note that the submission would be that the mineral value is not the sole preserve of entry 50 list 2. Stamp duty, the law itself contemplates royalty as a measure. And if your lordship will look at entry 54 list 2 sales tax as it existed before GST,
Yes.
before the 101st constitutional amendment, 2016. It was sale of tax on sale of goods. So mineral would have fallen there. And states have been recovering under Sales Tax Act, and it's the sale price. So the entire mineral value is a measure in sales tax also. Yeah, if it's a declared goods, minerals is declared goods, then central government will fix a certain rate.
Ceiling will be there.
That's the limitation. Constitution has given enough indication, the framers, as to what is limitation. And I had referred to 86.3 also in that connection.
That was section 15 of the central sales tax. Act.
Section 50, I am grateful.
It says
Section
4%
50,
or 3%.
4%. It's not blocked by a prolix and expansive search all over the places, like searching a needle in the haystack, my lord, and then come out that this is tax. Occupied field. So occupied field has nothing to do with this. The parliament does not occupy the field of taxation. It's a limited concept. As my lord said, my lord, Justice Nagaratnam, my lord, that you can extract everything from 23. But there also to the extent. Yes.
Provide.
It's not sub silentio. Parliament by law provide extent.
That put cap on the limitation rate. Huh?
Not state government, but not by rules, not by forms.
I'll just share with you.
So the 4% will come from section 15, but mineral value, the sale price of the mineral value will be its basis. And not only state tax, minerals. Parliamentary tax also, excise duty if they want to levy on the production of minerals, which they are levying, it will be based on the mineral value. If you want to impose export duty under customs duty, again, my lord, it will be based on mineral value. So there's no such thing, my lord, that other tax entries cannot, my lord, we at all have a measure which is connected with mineral value.
We hold it.
It's not the sole preserve of entry 50 list 2. Lord, that mineral value, the measure based on mineral value is not the sole preserve of entry 50 list 2.
Measure based on
mineral value or a portion of mineral value. So how else a capacity of land can be measured? Salve said capacity of land should be. How do we determine the capacity of land? Same extent of land of same nature lying in Noida will have one value, coming back to Delhi, its location, its use, what the master plan is permitting. The moment you turn a lease, the residential land into a commercial land, the same land's value will go up. So the capacity of land depends on what it can produce, where is it located, what is the permissible use. Here the permissible use is mining for the mineral which is lying in the belly of the earth. So stamp duty, erstwhile as the sales tax stood, and even today oil, still there. Under 54, a sales tax is still being levied on oil, crude oil and also on variations, gas. And it is based on sale price of those items. Similarly, in the Central Act, that is excise duty, customs duty, tax on capital assets, all of them will be based on this. So merely because you find that we have imposed a tax on land based on mineral value or half of mineral value. So this also must be decided, but assuming I'm wrong in this and Lordship doesn't agree that mineral value as a whole can be used. Why can't not a part of it be used, let's say, as Odisha has done, percentage of half of the mineral value? So land's worth has to be determined in some way. Why can't we say 25% of the mineral value? And if it is still disrupting some national policy or something, there can be a dialogue. After all, states have voluntarily united to create a union. Article 1 says India, that is Bharat, is a union of states. So union and states have to gel together. They can't afford to all the time, despite the politics which is conflicting and introduces an element of conflict. But cooperation is also there, has to be there. So if there is some such situation arising or not, that government of India feels that their whole economy will go bust and there will be disaster, etc. I don't think any state possibly will be saying no to reduction of tax or to grant a holiday of tax. What are we witnessing around? Should we close our eyes to what the states are doing towards the industrialists? Red carpet minutes. They can walk into the chambers of the government at any time. It's the common man who can't walk. Even the chaprasi that will stop him. Appointment hai ki nahi. But they can just a phone call and they will be escorted into the interior chambers. But I'm not casting it. That's the capitalist phenomena which is all over the globe, not here alone. So they can always walk there. In fact, these companies are themselves competent to pressurize the government to reduce the taxes. We can't do it.
Anyway, Parliament has the power
Yes.
to impose limitation.
Yes, that's on one tax. One may say that all right, you can get out of this and then go into 49, go into stamp duty. This argument of 300%, 500%, at one point of time in 1990s, the figures have been given by the learned Solicitor General that 300, 500, because the royalties, etc., were very low and therefore that they needed revenue and that. But today, no state is revenue. Affidavit is silent on one very vital aspect. Post Keshavaram, at least in West Bengal, for the last 20 years, this tax is being levied. What disaster has happened? Should not the government of India tell your lordships, my lord, that this West Bengal tax has caused what impact? Has it burnt the economy? Has it prevented any obstacles for export, import?
In any case, state tax is high. Royalty can be anytime reduced by the government.
Yes.
Because
I'm grateful.
embargo is on increasing the royalty. That can be done only once in 3 years. But reducing it can be reduced anytime.
Government of India has more than one power, my lord, to tackle a situation of disaster. So let this not be a subterfuge, my lord, to bang the states. Our state of West Bengal is levying tax on mineral rights as upheld in Keshora for 20 years. What is the proportion of that tax to the total, my lords? How is it impacting? That's the real test. We say, you know, the proof of pudding is in the eating. Here is a tax which is being levied for 20 years. Why don't you analyze that and tell the court, my lord, that what disaster is happening? Or are we to hallucinate, my lord, that some disaster is just the moment, my lord, the state touches 1 rupee per. Jharkhand says 1.5 rupee, my lord, per square meter for land. No mineral value. And it's lying stayed here, my lord, struck down by the High Court. Based on these series of cases based on para 34. What is nothing to do with mineral value? What disaster would have happened? The employees have not been paid their salary for four years. The tax is not a return. It's not a consideration. That it's a compulsion. That's not a complete analysis. Okay, compulsion, penalty, this. It's a recovery of amount to be spent by the state for its own needs and for welfare activities, not to give you back something. But the structure, the construct of Mr. Salve's submission was avoid the word tax, use exaction. So it's an exaction for return. Look at the essence of entry 50. It is also an exaction for return. So bring it on the same plane, and then it's a limitation. That's how we read down one tax on mineral rights as becoming something which is a return for mineral rights. Compensatory tax. Your lordships, after great effort, have been able to avoid compensatory tax in entry tax matter. At least 4 constitution benches and 1 7-judge bench, your lordships overruled. And everybody agreed that it can't be compensatory tax because compensatory tax means it's a fee. No, you are.
There are exceptions to that.
Yeah. So having knocked down compensatory tax in context of part 13, now we introduce compensatory tax in entry 50 itself. So unless it becomes compensatory, it can't be equated, it cannot be a limitation. So these are the strange methods by which we alter the innate character of royalty. Now please see one more article in the Constitution, that's 294. And the purpose of showing this is that my right to land and mineral lying underneath in its belly is not a gift of Mines and Mineral Regulation and Development Act. The Parliamentary Act can regulate it, but unless it acquires all 294, all the provinces, state provinces will not under all property and assets which immediately before such commencement were vested in His Majesty for the purpose of the government or of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purpose of government of each governor's province shall vest respectively in the Union and corresponding state. Only the continental shelf was taken out. So the erstwhile ownership transferred to province, we continue to be the owner, of the land and mineral and whatever is subsequently acquired by the states under Land Reforms Act, under the abolition of kingships. So, किस पे है जहाँ लिखा है वो Lords, kindly have volume 1C. Volume 1C, which is a rejoinder submission.
Volume 1C. You have covered the core of your submission with
Yes.
this here.
At page 7.
4C. 4C. So 1C. 1C. 1C.
1C.
Page 4.
Lords, have that? My Lord the Chief Justice.
Yes.
Because at the bottom, I have done nothing but repeated what your lordships sutras, as Mr. Singhvi said. Kindly come to page 8. I have also mentioned entry 13 where some more than one sutras are involved.
Page 8, which?
Para 4.
Para 4.
If your lordship looks at entry 23 and 27 and 67 of list 1.
Entry 27 of list 1, right? Or list 2, sorry.
Twenty 23 of list 1. Highways declared by or under law. Please mark this. I'm drawing a distinction between entries which say by law, by Parliament by law, or those which say by or under law. That will create a structural problem with respect to section 9 being understood as a tax.
Which entry were you saying? List 1?
23.
23.
Highways declared by or under law made by Parliament. And then 27, ports declared by or under law made by Parliament or existing law to be major ports, including their delimitation and constitution and powers of port authorities. And then 67, ancient and historical monuments and records and archaeological sites and remains declared by or under law made by Parliament. Perhaps the Lordship will notice a box there. Declared, earlier it was declared by law. But by Constitution's 7th Amendment Act 1956, it was altered. At the foot of that book, you'll also see that earlier. Now, entry 12 of list 2 libraries, museums, and other similar institutions controlled or financed by the state, ancient and historical monuments and records other than those declared by or under law made by Parliament. A reflection of that amendment is here also. And then entry 40. Of list 3.
Same. Taxes amendment. Sorry. 50.
Archaeological sites and remains other than those declared by or under law made by Parliament to be of national importance.
Under the statute itself.
And under
Now compare this lot with entry 54, 52, 53 and 54 of list 1. Regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, industries, the control of which the union is declared by Parliament by law. Parliament has to do this exercise by its law, and it cannot empower a delegate to make the requisite declaration or to lay down the extent.
That could be by a notification if it is
That's right,
under law.
because one legislature is dealing with another legislature, the central legislature vis-a-vis the state legislature. So central legislature has to do it. It can't say that I'm delegating this power to the government or some other authority or officer of the government to lay down limitations. '53 also in the area of oil fields and mineral oils declared by Parliament by law to be dangerously inflammable. No government or officer can say, I will declare it, or I will declare in part and leave it rest to the government to declare. '54 also. Mines and minerals, to the extent to which such regulation development under control of union is declared by Parliament by law. Parliament also cannot say that, well, I have made the law, section 2 is there, now rest will be laid down by rules, as was earlier done in 1948 Act. It did nothing but said rules will be made. That was Constituent Assembly. But now that the Constitution is in force, it has to be done by Parliament, by law. So by law, you have to provide the extent. If you want to alter, reduce or increase a tax or a limitation or a different kind of limitation, has to be by law. But my learned friends have been taking your lordships to the rules, the forms, and all those stipulations, because it is general principle is that a delegated exercise is considered to be part.
63, then 62, 63, 64.
Yes, there are other entries also. 56 is also there.
Or under law.
Even article 50, entry 56.
Yes, entry 56. I'm grateful. 56 also. 60,
64.
64.
No, but this doesn't mean that everything has to be specified by the law.
Saying that.
The control, the extent of the control by the union has to be declared by the law.
Declared. Rest minor things.
Once the extent of the control is specified in of Parliament, then of course the rule-making power can supplement it.
Nitty-gritties and minor details may come by rules and forms.
Right.
I'm not saying that the form must come in the act itself.
Declaration cannot be by a delegate.
Declaration can't be an extent of declaration.
Right.
Parliament, your lordships have ruled in case that Parliament cannot say that section 2 I have brought in, now rest is to be done by government. So what minerals you are, the important aspects of the declaration, because you are extracting from 23. You are depriving the state legislature of its competence. That's the crucial thing. And that's why it says to the extent. And even where entry 52 did not use the word to the extent.
It is not there.
In Ishwari Khetan's judgment, your lordship's constitution bench has said that we will read in that word. Some meaning has to be given, my lord, to the word extent of,
Yes.
because you are extracting, depriving, denuding. It can't be sub silentio. Some nitty details can come in. The form can be prescribed. Many other things can be done. Right? How you will recover royalty, how you will recover surface rent, all that can be done by rules.
But under entry 52, the control of the entire industry,
Yes,
which is declared, is with the Parliament.
Parliament.
Unlike 54. It is 54 is only to the extent to which it is declared.
My lords are right, but in Ishwari Khetan, your lordship said that even those words are missing in 52.
So they
But-
read it down.
But we will read it
With that
because,
condition.
yes, I'll, if required, I can show that. In Ishwari Khetan words, I'll show. Yes. For the moment, this distinction which I am pointing out has relevance to understanding the limit of limitation in entry 50. Entry 50 list 2 says any limitation imposed by Parliament by law. Not by or under law.
And
So
that
the framers have been,
also, that extent to which is only in the context of regulation of mines and mineral development.
your lordship is right.
That's because
The words are missing.
for the limitation.
The words are missing in 52. My lords are right. Absolutely right, not. But in Ishwari Khetan, if I may give this judgment is in volume.
So really speaking, entry 50 of list 2 makes it very clear that the limitation has to be by law of Parliament.
Yes.
Second, that law is again, the content of that law is qualified by saying it has to be a law relating to regulation and development of
Yes. So the major aspects, the major policy aspects of the law must come by the law. They can't leave that to delegates. That is paragraph 11 of Ishwari Khetan, which is in volume 5A. And the citation is 1980, volume 4, SCC 136. 1980, volume 4, SCC 136. Paragraph is
So
devoted.
one thing is very equally clear that you have to also possibly concede. Ms. Bhati yesterday made just one sentence, but it was a very succinct sentence which she used, that the power of the state in regard to taxation is eclipsed not by a taxing legislation of the union, but by a regulatory legislation of the union.
That's right. No difficulty. With this statement, I have no quarrel. But I have a quarrel with the use of the word eclipse.
It is subject to, and therefore.
Normally, eclipse word, Lord, the doctrine of eclipse was deployed by lordships under when
Become
an
a-
existing law under 372, Lord, is found to be violative
to
of
apply
13.
that way.
13.
So then
Article 13.
it was valid when made.
Was it
now
stillborn or was it only under a cloud, and is the cloud lifted?
And once again, if you go to the nature, Lord, an eclipse happens when something covers the lunar eclipse or the solar eclipse, Lord, some other object comes in between. Law MMRD Act cannot come in between, cannot extract, cannot usurp, cannot arrogate. The relationship of 54 list 1 to 23 list 1 is of one character. And the relationship of entry 54 and entry 50 list 2 is of another character.
Can you just wait for a second? Hold your thought there just for a moment. I'll just.
You please repeat it.
Yes, the relationship between entry 54 list 1 and entry 23 list 1, entry 23 of list 2 is of one character. Namely, you can abstract, denude it as much as you want. As much as Parliament wants. And the relationship between entry 54 list 1 and entry 50 list 2 is of another kind and character, which does not permit abstraction, only limitation. Lord Justice Nagaratna has noted this Ishwari Khetan's citation.
Yes, yes.
Para 11. Hypothetically, my lords, assume, my lord, that instead of the same expression was there in entry 23 as in entry 50, instead of subject to limitation, would it remain identical or would it bring about a substantial change in the nature of the relationship? In that case, then, even the regulation will always be exercised by the state. So therefore, Additional Solicitor General states that entry 54 list 1 being a regulatory power can limit. I have no quarrel. Limitations can be imposed. But if it is said, when she says that this eclipses, then there is a problem. Stricto sensu, the doctrine of eclipse as propounded is for a different purpose, where either the competence is lacking or some other constitutional provision is being violated by an existing law, then, my lord, under. But let's forget that technicality and go by the literal expression. Even then, something should come in between. The only thing that can come in between is a limitation. The power of limitation has its limits. So please discover the limit of limitation. It's not unlimited. Otherwise, the easiest thing was to accept Shri Brajeshwar Prasad's request to transfer entry 50 list to list 1. The easiest thing, Lord. If you can eclipse, then take it. I have already placed that. Every debate, my lord, which happens on a constitution necessarily goes across the seas, my lord. The ships sail. So the House of Commons debate was read out to your lordships. It's no different. Mr. Percy, you can be substituted by Mr. Prasad. My lord.
I think that's what you want.
What he was wanting, Mr. Prasad was wanting. And on both occasions, that was not accepted. That's the key important thing. In a debate in an assembly where constitutions are being framed, so maybe speakers say so many things. Ultimately, what is being accepted and rejected is the important thing. So both in the House of Commons and here, although they were paramount, sovereign could do anything.
That Bridgeshwar Prasad part, can you just tell me which volume and volume?
Volume 4A at page 16 starts at page 10.
Mr. Dwivedi, your junior is a walking encyclopedia. We have noticed this in repeated constitution benches.
Yes.
So according to you.
The last time we allowed her to make that submission in the constitution bench, today also we are going to hear her after you have concluded for 5 minutes.
She is well armed today, Milord.
She's probably anticipated what's coming.
Volume 4A.
Volume 4A, 17 to 16, Your Lordship, and the relevant is at page 16. With regard to entry 15 and with regard to entry 54 is at page 10 and 12.
Just come again, please tell us.
Volume 4A. And the debates start at page 7, Your Lordships. So far as entry 54 is concerned, page 10 and 12. And entry 50 is page 16.
Yes.
Which you
When
can-
we lay down our boots, we should at least feel that.
Another way of saying occupied field, nothing else. The principle of occupied field is completely unrelated to the relationship between 54 and 50. Can't occupy the field, occupy the.
Just to probe you a little bit on this, what kind of limitations would entry 50 contemplate? Would these be limitations contained in the law relating to mines and mineral development of an express nature on the taxing power? Or could it be something more than just that's one way of reading it, that you read the word limitations in a very narrow sense because you're carving out of the
Competence.
competence of the states. That's one approach. But does it have to be an express limitation on the taxing power itself under entry 50?
So in one, my lord, if I have to rely on a judgment, in 9 judges' judgment in Jindal, your lordship said it has to be express. All constitutional limitations must be expressly stated, either in the constitution or the laws. That's one. Second, my lords, the framers of the constitution have
In
given.
what context? I think both I and Justice Ramana in our judgment we referred to that, I think.
Yes.
So
Lords,
what
the main
context?
judgment of the Chief Justice Thakur also, my lords. That was in the context of
13, of course.
304B,
304B, you are right.
which requires that if it is reasonable restriction, then you have to refer to the president for assent. So the contention was that if every tax law is to be placed before the president, it being violative of 301, then all fiscal federalism is gone. So, my lord, the Chief Justice, my lord, you handled, my lord, the issue in a slightly different way. My lord, your lordship said that under 301, all taxes are not impediments. So the people who are challenging, but they must produce enough material to show that it is an impediment on free flow of trade. Whereas the Chief Justice Thakur said that it can't be a restriction. That was the divergence, but at the end of the day, unanimously, the taxing power was disentangled from the grip of 3 and 4B so that the states are free now. That's in fact a very important aspect. That's para 28 of Chief Justice Thakur's judgment. It's 2017-12 SCC. Page 1. It's in volume 5 at page 2937. The discussion begins at page 28 under the caption constitutional limitations must be expressed. At 3074.
Volume 5, right?
.3074. May I place it?
Just a second.
The power to levy taxes.
Just 21 seconds. Limitations must be expressed.
Which paragraph, sir?
The power to levy taxes being a sovereign power controlled only by Constitution, any limitation on that power must be expressed. That proposition is well settled by the decisions of this court in Eclipsing versus State of Bombay and from Bansidhar, Prem Sukh Das versus State of Rajasthan. In Eclipsing's case, this court stated the legal position in the following words: the legislative competence of the state legislatures can only be circumscribed by express prohibitions contained in the Constitution itself, and unless and until there is any provision in the Constitution expressly prohibiting legislation on the subject either absolutely or conditionally, there is no fetter or limitation on the plenary powers which the state legislature enjoys to legislate on the topics enumerated in the list 2 and list 3 of 7th schedule of the Constitution. The fetter or limitation upon the legislative power of the state which had plenary powers of legislation within ambit of legislative heads specified in list 2 and 3 of the 7th schedule to the Constitution could only be imposed by the Constitution itself and not by any obligation. Here one can substitute Parliament under entry 50. And not by any obligation which had been undertaken by either the Dominion or the province of Bombay or even the state of Bombay. Under Article 246, state legislature was invested with the power to legislate on topics enumerated in list 2 and 3 of the Constitution, and this power was by virtue of Article 245(1) subject to the provisions of Constitution. The Constitution itself laid down the fetters, limitations on this power, for example in 303, 286(2), but unless and until the court came to the conclusion that the Constitution itself had expressly prohibited legislation on the subject either absolutely or conditionally, the power of the state legislature to enact legislation within its legislative competence was plenary. Once the topic of legislation was comprised within any of the entries in the list 2 and 3 of 7th schedule to the Constitution, the fetter or limitation on legislative power had to be found within the Constitution itself, and if there was no such fetter or limitation to be found, the state legislature had full competence to enact the impugned act, no matter whether such enactment was contrary to the guarantee given or obligation undertaken by the Dominion. Again, in Bansidhar, this court reiterated the legal position. It is well established that Parliament or the state legislatures are competent to enact law altering the terms and conditions of previous contract or of a grant which under the liability of Government of India or of the state government arises. The legislative competence of Parliament or state legislature can only be circumscribed by express prohibition contained in the Constitution itself, and unless and until there is any provision in the Constitution expressly prohibiting legislation on the subject either absolutely or conditionally, there is no fetter or limitation on the plenary powers which the legislature is endowed for legislating on the topics enumerated in the relevant lists.
I think that's good enough.
Yes. So this goes on, I'm not reading.
No, then it goes on to part 30.
Yes. Justice Bhanumati's paragraph on judgment paragraph is para 281 and Justice Ramanna is para 185. But the only difference will be that under entry 50, Parliament can impose limitation, but must do so expressly. But what is there? I don't understand what is the hesitation? Parliament knows its policies, industrial policy, mines and mineral policy, everything. They know the export, import, the need of FDI and so on, so many things. What prevents them, my lord, from having one provision is saying that, and just look at 276, Article 276. I've already referred to Article 286.3. 276 is yet another provision where framers have indicated how they understand this limitation. Taxes on professions, trades, callings, and employments. Notwithstanding anything in Article 246, no law of legislature of state relating to taxes for the benefit of the state or of a municipality, district board, or local authority therein in respect of professions, trade, callings, or employment shall be invalid on the ground that it relates to tax on income. The total amount payable in respect of any one person to the state or one municipality, district board, local board, or authority in the state by way of taxes so and so shall not exceed 2,500 rupees per annum. So the framers, where they found that the measures are overlapping and they wanted to protect it, instead of eliminating it, they allowed it and said, here is the limit. There is ample indication in 276 and 286.3, read with the Central Sales Tax Act. Why should not the Parliament analyze everything? Look at the operation of West Bengal. By affidavits, we can't create, my lord, a doomsday. All state legislatures are responsible 300%, 500%. What prevents the Parliament? Supposing if I say, my lord, the Parliament imposes 500%, 300%, that disaster. It can be said vice versa to that also, but we don't say that. We assume that they will act with constitutional responsibility.
You know, at one time in India, we had a 97% tax on income. Coupled to the wealth tax. In fact, the real rate of taxation went up to 103%. 103%.
So sometimes the taxes are also imposed to control the exports. We don't want a mineral to be exported. We'll say 100%, so nobody will export and sell here. So there are but Parliament knows all these things. The Finance Ministry knows, the Commerce Ministry knows. They can all deliberate and say that here is don't impose it more than this. Don't impose on royalty.
My father used to always.
Yeah. So पैरा निकाल दो उसका जिंदल का Yes, Your Lordship, my Lord, the Chief Justice has Mohit Mineral. Your Lordships have talked about fiscal federalism.
Yes.
What is the citation of Mohit Mineral?
2022, 10 SCC, page 700.
At which para?
Para 50, 52. In fact, it begins at para 47. To 58. Where your lordships held that state governments are not bound by the recommendation of the council. It's only recommendatory. And this principle was up to para 59.
Mr. Dwivedi, you have incorporated it in your
Submission.
Yes, I have.
You may just read that paragraph. Just, we have 5 minutes to go before we close for lunch. Para 10,
Para 10, is it?
para 10.
Which volume?
1C.
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 Lordship, on the judgment or from the written note?
From your
Written note.
1C
You have quoted paragraph 56.
and 171.1.2.
Page 11 of your note.
Yes.
Para 10. Recently, this Honorable Court in Union of India versus Mohit Minerals, while holding that fiscal federalism is one of the important features of Indian federalism, held that the recommendations of GST Council cannot be held to be binding on the legislature. To regard them as binding edicts would disrupt fiscal federalism, where both union and state are given equal power to legislate on GST. One of the important features of Indian federalism is fiscal federalism. A reading of the Statement of Objects and Reasons of the 2014 Amendment Bill, the parliamentary reports and speeches indicate that Article 246A and 279A were introduced with the objective of enhancing cooperative federalism and harmony between the states and the center. However, the center has a 1/3 vote share in the GST Council. This, coupled with the absence of the repugnancy provision in Article 246A, indicates that recommendations of the GST Council cannot be binding. Such an interpretation would be contrary to the objective of introducing the GST regime and would also dislodge the fine balance on which Indian federalism rests. Therefore, the argument that if the recommendations of GST Council are not binding, then the entire structure of GST would crumble does not hold water. Such a reading of the provisions of the Constitution diminishes the role of GST Council as a constitutional body formed to arrive at decisions by collaboration and contestation of ideas. Neither does Article 279A begin with a non-obstante clause, nor does Article 246A state that it is subject to the provisions of Article 279A. Parliament and state legislature possesses simultaneous power to legislate on GST. Article 246A does not envisage a repugnancy provision to resolve the inconsistency between the central and the state laws on GST. The recommendations of the GST Council are the product of a collaborative dialogue involving the Union and the states. They are recommendatory in nature. To regard them as binding edicts would disrupt fiscal federalism, where both the Union and states are conferred equal power to legislate on GST. It is not imperative that one of the federal units must always possess a higher share in the power for federal units to make decisions. Indian federalism is a dialogue between cooperative and uncooperative federalism, where the federal units are at liberty to use different means of persuasion, ranging from collaboration to contestation. So, although the context is the GST and parallel power, but ultimately, the whole trend of this court's journey with regard to federalism begins with Keshwanand, where your lordship recognize it is a basic feature. Then Bommai and then ITC versus agriculture, 4 cases where lordships have felt that where there is lack of clarity, ambiguity, etc., then tilt in favor of protecting the state's niggardly powers rather than by interpretation, by some legal subterfuge, dilute it, reduce it, or obliterate it. That's the principle. And not only there, we are witnessing today, my lord, the conflicts between the state. Howsoever we may avoid this, the conflict where the governors holding the files, your lordship said you cannot. Orders were passed for premature release. Governor was not signing. Then in Periyapalan's case, your lordship said that no, you have no authority in that regard. So in so many spheres, Article 356 itself, your lordship strictly construed. The earlier laws were all overruled and a new law was laid down. So the whole journey of this court is to protect the state, and the surest way of killing the states, the federalism, is to squeeze and strangulate the fiscal power.
My lord, my learned friend is finishing now. It's there are a number of new points he has made because, frankly, we really opened the case. He has answered. How would your lordship like?
New really. Mr. Survey, where is the?
There are a number of points he has made on decoupling.
I'm not finishing. Just hold on.
Oh, you are continuing after lunch. I'm so sorry. I thought you were finishing at 1.
Oh, you want it again? Alternate benches discharge. We'll discharge the alternate benches. Alternate benches discharge. It's not sorry.
I'm sorry, my mistake. I was told you're finishing at 1.
Lord, your lordships may give me 5 minutes on federalism, my lords.
I don't know. It's all right. These are
What is this?
well settled principles.
Yes.
So
My
correct,
lord,
my lord.
there are some important points my learned friend has made, including on
Written
MMD.
submissions
today.
can be given first.
All right. You can give us a small note.
I don't think it's for you, Mr. Dwivedi. It's for the court to decide. May I suggest, my lord, after he finishes,
We'll
give us half an hour.
Don't be so stern. I'm just lighter vein.
All right. We'll come back.
Give us 30 minutes, my lord, at the end.